My talk today is going to be on how to write convincing letters, particularly letters of demand that I've written as a lawyer. I had a good teacher. It was my first boss, Richard Walsh at Angus and Robertson Publishers, which was my first job. Richard could write letters that could convince people of many different things, and a feature of his letters was their length, their detail, their honesty, and his beautiful use of language. Now, when I left that first job, I joined a law firm and I saw how stilted law firm letters were. And because I had learnt the proper way, I continued that practice. So I found in my career that my letters can be very effective. And I want to share some of the features that I find useful for writing effective, convincing letters of any sort, but in particular, I'll be referring to letters of demand. Now, the first thing I'm going to talk about is the structure of the letter. You've got the address at the top, you've got a date, you've got the regard section, which ideally should be in a larger font size than the body text. That way it'll get noticed more. Then you've got the subheadings in the letter. There should be quite a few of them if possible. And they too should be in a slightly different font size. They should be bold than the body text. And then you've got the body text. Now, the body text, if it's a serious demand letter, will often be a numbered list, meaning that each paragraph will have a number. Now, that works really well in demand letters, which follow the normal course, which is that the letters have a chronology to them. They go from the beginning of the story to the middle to the end. So the fact that it's numbered gives the reader a sense of direction, tells the reader that the second item and the third item follow naturally from the previous items. So that's the structure of the letter, and of course, there's a signature at the end. Now, in terms of how you begin to write a letter, the first thing you've got to do, which should be the most time-consuming thing that you're involved in doing, if you know some of the law, so you don't have to really look that up, the most time-consuming thing is gathering the facts. Now, if you've got the chronology of the events that have occurred that have led up to the need to write this letter to convince somebody to do something in particular, if you've got that chronology, then really you can input it into what I describe as the three parts, particularly of a demand letter. So the first part takes up most of the space, and they are space taken up with facts. So that first part is full of facts, and as I've said, the facts can be highly chronological, which helps people understand where you're going. Once you've dealt with the facts, the second part of the three parts will be the statement of the law if it's a legal demand letter. Now, that statement of law need not be very long. You're not writing to another lawyer convincing them of what the law is, or let alone a judge with a court document. No, you're just simply indicating to the party that's receiving this letter that there is law that has framed all of those facts. And in fact, as I'll mention shortly, if you've written the letter with the right tone, a brief mention of the law will be sufficient. The third of the three parts of the letter are the demands. Now, the demands can be short. It might just simply be that you want somebody to do something by a certain date, or the demands can be extensive. There might be 15 things that somebody needs to do if they're infringing a trademark or a copyright, and you want them to remove the information from a relevant website, or, I don't know, Facebook post, whatever. So the demands and the number of them vary, but the demands need to be, just like the facts, extremely precise. Otherwise, you get these quibbles as to, well, you didn't say how I should do what you wanted me to do, and I've decided to do it this way. You've got a schmozzle then. So make the demands extremely precise. Now, finally, I'll go back to what I mentioned earlier about the tone of the letter. Throughout all of this writing, it's important to try to separate emotion, but when you do use emotion, it should be very subtle. As a final point, I was once complaining about a solicitor to the Law Society, and when I called, and this had been a matter where the complaint that I had felt on serial occasions, and I couldn't take it anymore, so I rang the Law Society and spoke to the ethics officer, and I asked, what should I say to this lawyer to try and change his behaviour. And the ethics officer said, use the word concerned. Say you are concerned. That's when I realised law can be very subtle. So I used the word concerned. The behaviour changed. Thank you for listening. I hope you gained something. Bye.